Welcome to Black Letter Money. Wage theft is the largest form of theft in America. According to the Economic Policy Institute, employers steal up to $50 billion from workers every single year. To put that into perspective, all the robberies, burglaries, and motor vehicle thefts in this country combined amount to less than $15 billion. Now, technically, what they are doing is illegal. The Fair Labor Standards Act prohibits it. Federal law prohibits it. But most workers are unaware of their rights, enforcement is rare, and the consequences for employers are minimum. So in practice, it might as well be perfectly legal. In this video, we're going to cover the three most common forms of wage theft: unpaid overtime, off-the-clock work, and tip theft. All three are violations of federal law. All three happen consistently, and in each case, I'm going to tell you what exactly the law says and what you can do about it. A few things before we get started. First, this applies to employees covered by the Fair Labor Standards Act. Most workers in the U.S. are covered, but independent contractors, certain agricultural workers, and some other categories are not. If you are unsure whether you qualify, I encourage you to look into it. Second, this is not legal advice. This is black letter law, written directly into the FLSA, explained clearly so that you know your rights. Under the FLSA, most covered employees are entitled to overtime pay, which is 1.5 times the regular rate. This is for every hour worked beyond 40 in a single work week. Not a pay period, a work week. These are different, and the distinction matters. The most common way employers avoid paying overtime is through misclassification. They give an employee a manager or supervisor title and use it to claim the worker is exempt from overtime requirements. But a title alone means nothing under the law. To qualify as exempt under executive, administrative, or professional exemptions, what are called white-collar exemptions, two things must be true. First, the employee must earn a salary of at least $684 per week under current federal law. Now here's where it gets interesting. The DOL tried to raise the threshold to $844 per week in July 2024, and then to $1,100 per week in January 2025. But in November 2024, a federal court struck down the entire 2024 rule, reverting to its threshold of $684. As of today, $684 per week is the enforceable federal floor, though this is actively being litigated, and your state may have higher thresholds. Be sure to check your local state laws. Second, the primary duties must genuinely involve management, independent judgment, or specialized professional knowledge. If your employer gave you a manager title, but you spend most of the time doing the same work as the hourly employees around you, you likely do not meet the duties test, and you may be owed overtime you never received. Off-the-clock work means work your employer knows you're doing, but is not compensating you for it. Things like answering work emails after your shift ends, setting up equipment before you clock in, staying late to finish a task you were told need to be done, or attending mandatory pre-shift meetings that start before your clock starts. Under the FLSA, employers are required to pay for all hours worked. That includes work performed outside of scheduled hours if the employer knew or should have known the work was being performed and allowed it to continue. The phrase, "we don't authorize overtime work," is not a legal defense. If the employer benefited from the work and was aware of it, the hours are compensatable, period. The key phrase here is suffered or permitted. That's the actual statutory language. If your employer suffers or permits you to work, in other words, they allow it or benefit from it, even without explicit authorization, they owe you compensation for that time. That standard comes directly from 29 CFR section 785.11, and it is one of the most important phrases in wage law. Tip theft. This is exactly what it sounds like. Employers taking money that legally belongs to their employees. Under federal law, tips are the property of the employee who earned them. Full stop. Employers cannot take a cut of tips for themselves. Managers and supervisors Anyone with authority to hire, fire, or discipline cannot participate in tip pools, regardless of whether those employees regularly receive tips themselves. The Consolidated Appropriations Act of 2018 amended the FLSA explicitly on this point. Before 2018, the rules around tip pooling were more complicated and varied depending on whether the employers were using a tip credit. After 2018, the line became much clearer. Employers and managers cannot touch the tip pool, period. Employers who illegally take tips can be liable for the full amount of tips stolen, plus an equal amount in liquidated damages, plus attorney fees and costs. One important nuance: if your employer pays you the full federal minimum wage and is not taking a tip credit, different rules may apply regarding tip pools that include back-of-house employees like cooks and dishwashers. In this situation, sharing tips with back-of-house may be permissible, but your employer still cannot take tips for themselves, and managers and supervisors still cannot participate. That line does not move regardless of how you are paid. If you believe your employer has stolen wages from you, here's exactly what to do. First, document everything starting now. Keep your own personal records of hours worked, tasks performed outside of your scheduled hours, tips received versus tips paid out, and any instructions you received to work off the clock. Write it down with dates and be as specific as you can. Your own concurrent records will carry real weight. Second, file a complaint with the Department of Labor Wage and Hour Division. The WHD investigates FLSA violations. Filing is free, and you do not need an attorney. You can file online at dol.gov or by calling 1-866-4-US-WAGE. The WHD can recover back wages on your behalf and has recovered billions of dollars for workers just like you. Third, consult an employment attorney. Many take wage theft causes on contingency, meaning they only get paid if you win. Under the FLSA, if you prevail in court, your employer pays your attorney fees. That means the financial barrier to create a claim is significantly lower than most people realize. The statute of limitation for FLS claims is 2 years from the date of the violation, 3 years if the violation was willful. That means wages stolen from you as recently as 2 or 3 years ago may still be recoverable. Don't leave that money on the table. If this is the kind of thing you wish someone had explained to you sooner, there's a lot more where this came from. Subscribe to Black Letter Money. This is what we do here, the law and the money, together explained clearly. See you on the next one.